Since the High Court's Timber Creek decision, compensation has become an increasingly important focus area within the native title sector in Australia. However, to date, attention has largely focused on how research for compensation claims are being produced in the more remote and northern parts of the country. Given the small window of time that an act can be considered compensable, which is roughly between 1975 and 1993, there is evidently a number of limitations in this emergent jurisprudence for its applicability in the southeastern states of Australia, where the effects of settlement occurred much earlier than 1975. Notwithstanding, there is a growing momentum in these regions, particularly within Victoria, towards reconciliation and truth-telling initiatives, which surround a broader political agenda to establish the first Aboriginal treaty in Australia. And subsequently, there is a clear appetite to focus attention on what opportunities may exist for compensation, and indeed what methodologies for research may be developed in these more settled regions of the country. In today's panel session, we will hear from one of Australia's leading compensation barristers, Stuart Glacken, and anthropological perspectives from Wendy Ash, who was involved in research for the Timber Creek claim, and Dr. Mick O'Kane, who is the research manager at First Nations Legal and Research Services in Victoria. Given the complexity of this topic, we will aim to flesh out some of the fundamental questions regarding the role that compensation may eventually play in Southeast Australia. However, we will continue these nuanced discussions during day 3 of next year's 2022 CNTA conference. Today, we will firstly hear from Stuart Glacken. Stuart is a preeminent Melbourne-based barrister with extensive experience in native title and compensation matters. He has provided counsel to Aboriginal groups throughout Australia and has represented the interests of his clients in a wide range of claims. Specifically, Stuart has been instrumental in the foundational claims for compensation in Australia, including as counsel for the claimants in Griffiths versus Northern Territory. To ground our discussion today, could you please provide a general overview of the legal framework of compensation for us, Stuart? Firstly, what is it?
Well, what is it? I might remind people that in broad terms, the High Court addressed 2 issues. The first was how any objective economic component of loss on the extinguishment of native title might be ascertained. The second issue was how diminution in the connection between people and country caused by dispossession might be reflected in an award of monetary compensation. Now, in respect to the first issue, the legal framework included that third-party grantees wanting an interest in land could secure a valid title to the land through the agreement of the relevant native title holders, being essentially the effect of the Racial Discrimination Act. This was recognised by the High Court as providing a compensable economic exchange value. It's an adaptation of the way in which dealings in other land titles are given an objective economic worth by market value, even though in this instance, native title cannot be traded like a fee simple title in land. In the Timber Creek case, the joint reasons of Chief Justice Kiefel and Justices Bell, Keane, Nettle and Gordon referred to the loss of this exchange value of native title as an objective or economic effect of extinguishment. That's at paragraphs 84 and 85. And their honours described native title as having a, quote, recognisable economic worth, which lay in the sum that might be fairly and justly demanded, end of quote, for the lawful infringement of the rights. Now, the second issue concerning non-economic loss or cultural damage from dispossession was described by the High Court as having a subjective or non-economic component of loss termed as cultural loss or damage. The damage was compensable by reference to the customs of the peoples concerned, even though, for example, an enforceable legal right to control access had been earlier extinguished by non-compensable acts. And that's at the joint reasons, paragraphs 158 and 187. And the joint reasons employed the metaphor of a damaged landscape painting, describing the cultural impact as if there were holes punched into a painting that had previously been one coherent and integrated landscape. So if one keeps in mind that there are 2 components which provide the broad framework for our discussion.
So how does it work now? Could you explain a little bit more about that, please?
Well, all I can say in that context is that there's been a trickle of claims. There are two significant ones in the Northern Territory and one significant one in Western Australia. The two cases in the Northern Territory are being fought bitterly at this point by the governments concerned. And the one in Western Australia, there's apparently some talk of some negotiation. That then brings me to something that we'll discuss later on, and that is there certainly hasn't been a tidal wave of claims since Timber Creek. The aspect of cultural loss is quite complicated. It's not something that can be easily negotiated with governments, but nonetheless, in a number of spheres, there is significant negotiations going on, setting up frameworks in Victoria and Western Australia and Queensland, and New South Wales has a similar sort of model where they're looking at broader schemes to adjust how governments have been dealing with native titles since Timber Creek. So an example that I'm aware of in Victoria under the Traditional Owner Settlement Act, the governments are revisiting how they reach a standard formula for permitting activities over traditional land. In New South Wales, the Valuer General's gone through an exercise of how its office might value land that's affected by native title, all informed by the Timber Creek type principles.
So what are some of the opportunities and limitations to this developing jurisprudence in the southeast of settled Australia?
In the southeast or in more settled areas, bearing in mind those two components of economic and cultural loss, I think the High Court foreshadowed this in the reasons at paragraphs 98 and 217, where their honours recognise that there could be relative values of economic and cultural losses. And if I can perhaps read part of a passage of paragraph 98, where the joint reasons say that it may be that any sense of loss of connection to country resulting from the infringement or extinguishment of native title in higher value, developed areas is likely to prove less than the sense of loss of connection to country with respect to lower value remote areas. And of course, and that's the end of the quote, is that there's a converse. So there will be a value of higher economic loss in more developed parts of the country, but a lesser scale of cultural loss. Now, I think that's the lessons from Timber Creek when it comes to its application to more settled areas of the country. And as Wendy Ash will develop later on, is that the assessment of cultural loss in the experience at Timber Creek requires a fair amount of detailed background research on the nature of the connection and explaining that. You've got to explain the connection before you can then explain what's the significance of the diminution in connection.
So is there any difference between compensation and redress? And if so, could you explain what those differences are for us, Stuart?
Depends how you use the term redress, but an award of compensation by a court is certainly redress for past actions. What's important to bear in mind is it's not forward-looking. It doesn't provide a direct vehicle for empowerment over traditional country. Rather, the very premise to a compensatory award is the occurrence of past loss of control. So it's backward-looking in that sense. Proper redress, in my experience, requires forward-looking solutions, and they depend upon the negotiation of equitable settlements by which Aboriginal interests can participate in the economic development of their country. Now, some of these broader schemes that we're talking about, such as what's occurring in Victoria, I think will ultimately have as their objectives that sort of forward-looking perspective, albeit recognising what's occurred in the past, but to have any long-lasting settlement requires that sort of forward-looking perspective.
Stuart, will the 1975 to 1993 window be a limiting factor for compensation claims?
The period 1975 to 1993 has to be understood in a couple of respects. 1975 to 1993 refers to what's a period of past acts under the Native Title Act. And the most common form of a past act is where a government dealing offended the Racial Discrimination Act that commenced in 1975 or 31 October 1975. And then as from 93 or 1 January 1994, dealings regulated by the Native Title Act will give rise to compensation. So they're called future acts, and they're commonly dealt with by the negotiation of Indigenous land use agreements. So in fairly settled areas of both Victoria and New South Wales, there are determinations of native title, some made by consent. So if parties don't negotiate and agree on dealings for native title land in those states over those areas, there are compensation provisions for future acts which would engage the same principles that we're discussing. And then pre-75, it gets a little bit complicated, but it is technically possible that if there is a law, for example, a law dealing with the disposal of Crown land or mining interests that says that any interest in land should be protected by certain procedures, it's arguable that that would extend to native title interests, and therefore a breach of those state land provisions might give rise to a past act. But there's no established case law on that possibility. 75 to 93 provides a focus, but it's just happened to be, it was the focus in Timber Creek for the acts that concerned the development of the town, because the town wasn't established legally until a gazettal in 1975. So it was a nice sort of fit, and it was developed over 2 decades of a couple of subdivisions. But it would be wrong to think that the avenue for compensation is confined to those 2 decades.
Thank you, Stuart, for setting a really clear foundation for our discussion today. Now we'll hear from Wendy Ash. Wendy Ash has worked for over 25 years as a native title anthropologist, conducting research with Aboriginal groups throughout the Northern Territory, Western Australia, and Queensland. Specifically, Wendy has been involved in conducting anthropological research for the successful Timber Creek native title claim in 2006 and the subsequent Griffiths versus Northern Territory Timber Creek compensation application that was ultimately confirmed in favour of the claimants in the High Court in 2019. We will now hear from Wendy Ash on the nature of the anthropological research that was required in the Timber Creek decision. Wendy, you, alongside a few other senior anthropologists in Australia, have been delving into the types of methodologies and the themes of research that are specific to compensation. So I wanted to ask you, how can anthropologists reconcile research for the purposes of demonstrating continuity and connection, while also articulating cultural loss through the ethnography of emotion, feeling, and trauma for the purposes of demonstrating cultural loss?
Thanks, Courtney, and thanks, Stuart, for setting the scene. I think the first thing is just to remind people that the Timber Creek decision, 2/3 of the monetary compensation was for economic loss, and that was both economic loss, and then there was a calculation of interest accrued since that occurred. So probably by memory about 1/3 was on the non-economic loss, and that's where the anthropologists, I think, really come into it. I think Timber Creek, I feel very fortunate in that I was both involved in the original native title claim and then in the compensation claim. And there are really, it's an unfortunate in some ways in that that was the high point. And I recognise that even within the territory, we were incredibly lucky for a number of reasons. Firstly, that this was in a fairly remote area. It's a small town, it's a small Aboriginal community. The actual impact of European settlement was less than in more urban areas. Secondly, because of that, they had some of the traditional aspects of native title where you would see, for example, language is still retained. ritual is still there. People still have very much access to their country and are still using that country to a great extent. So with that proviso, I'll go into how we approached the cultural report. I think the first thing to say is that in approaching a compensation claim research, I would suggest you see it in two aspects. The first is actually you do exactly what you'll do under a regular native title report. You'd look into the spiritual and historical connection to country, the relationships between claimants, and the most important thing that Sturt reminded us is that the judge said that you couldn't take out particular parts of the country and say that they're there to be extracted out of the whole for compensation. So one of the most important, most important aspects is that you're proving the relationship between the claimants and the whole of their land. I think that's very important to bear in mind. But as with any native title claim, you're looking at management of rights and interest, the related duties and responsibilities, importantly, who has authority to make decisions, and the law and customs in Timber Creek, for example, are based on something called Yumi, which is the Aboriginal law. And that is associated with the dreamings. So the spiritual aspect obviously comes into it to a very significant aspect. So in the responsibility, looking after country, you're looking after things like introducing strangers to country, being aware of some of the spiritual potential dangers. So one of the aspects of senior traditional owner is that they're aware of the dangers. They would protect their own people by ritual responsibility, but they would also have the responsibility and the duty to introduce strangers. And in this case, it was done by head wetting from a river that a senior traditional owner or a traditional owner would introduce someone to country by head wetting. And that, of course, also gives certain permission for people to come in. They are a very important part of the responsibility of the country, for the country is that they have the responsibility to give permission to use resources, and their connection to the ancestors. They would call out to the ancestors. They might be assisted in getting the resources from their ancestors. So one of the problems with the alienation of country, of course, is that right to be asked permission is often taken away. So that's one thing to focus on. So then you go into what was called by the court the solatium, which is really the second aspect, which is quite different from a regular native title research aspect. So I think that's the way to approach it. Deal with the native title aspects that you would expect in any event, and then go on to the second aspect, which is what has been taken away. So as Sturt has explained, compensation relates to the emotional distress, the pain and anguish, and that would mean specifically perhaps a loss or damage to the country and a spiritual loss. So one of the things that Kingsley and I did was look at the local language, how people would express that loss or connection or rights and duties. So as I've said, and this is the Nulli-Wuru language, which was widely spoken amongst the claimants. So some of the language which they used, and you don't necessarily need an Aboriginal language. I think one of the things you need to focus on is when you're talking to Aboriginal people is the type of words they use, I think, are quite significant. So, for example, the three words we elicited were hark, which means broken or not able to be fixed, maring, which means spoilt, and puru, which means gut-wrenching. So all of those words in English are obviously relatable, and if you can get those sort of words, I think it really starts to elicit that strong emotional feeling. The negative aspect is also a personal and a communal aspect, and that's the failure to perform duties and responsibilities often elicit things like shame, blame, and therefore when people have that feeling, there needs to be some restitution for the loss or the shame that's felt. One of the things we were asked to do was see if we could find individual examples of loss or damage, and I did a quick look at our report. We found about 6 of really obvious examples, but there would have been many, many more. So the 2 I'll just give as examples are, one was within Timber Creek. There was, Timber Creek comes through the town, the actual river or creek, and behind the area of the hotel and the caravan park, one of the owners of that caravan park, he put concrete over this area of the creek where the dingo dreaming was said to be resident there. And this was considered to be one of the most horrific aspects of damage that was always brought up by the claimants. That was one of the first things they always brought up. And the interesting thing was that the actual individual who did that, who was not Aboriginal, who did the concreting, soon afterwards, he actually died in a single vehicle accident going into a tree. And that was interpreted by claimants as the dreaming taking retribution on that man. It was a direct response to that damage. Another example, which was a more personal one for one particular witness, was that there was a ritual headdress for humpyback dreaming who went through the country, and he left, at one point he left a stone which was representative of his ritual headdress. The person who was considered to have the main responsibility for that area when the senior claimant was not there was someone called Jerry Jones. I'm not sure if I'm meant to be saying the name, but anyway, he expressed enormous amount of shame and grief and guilt because at one stage there was a road being built, and the road workers removed some of the gravel and in the process destroyed that headdress. So even though Jerry himself hadn't done the damage and didn't even know that was happening, he felt very personally responsibility for it. And that's where the guilt and shame, those sort of words came in very much in his description of that incident. I think the last couple of aspects I'd look to focus on is the access and use of the country. So the town growth obviously means there's more and more restrictions for people. Europeans have taken over the main areas of the town, and the TOs don't feel comfortable often in the presence of Europeans, particularly if they're going hunting or fishing in areas where there might be a whole group of tourists who are fishing. They also said that, for example, that there were fewer fish than when they remembered as children. And again, some of the TOs used particular words. One man said he felt shy, he felt frightened and shame being next to some of these European people on his country. So the other aspect of that is the lack of access, but also not being able to teach their children about their country. So they weren't able to gather some of the resources on the country as easily, or they avoided that area. So that, again, the final thing I'll just mention is that there was this really obvious, intense and personal individual connection between country and dreamings. So one of the senior claimants, Alan Griffiths, said he felt a very personal relationship to his dreamings. He said they talked to him. So again, that use of language, that this is a personal aspect between him and the dreamings. And that he believed that the dreamings were actually a part of him. Again, I mentioned Jerry. He said he felt shame, he felt guilty. He thought people might think that he had given permission that for the road developers to take that rock. He might get blamed from other people. And he considered that he would be held responsible from both the dreamings and senior traditional owners who could become, or he himself could become sick or receive punishment from not actually protecting that site.
Thank you, Wendy. So I wanted to ask you, Wendy, now, how can anthropologists articulate incremental and accumulative cultural loss in ways that will meet the evidentiary standards?
Well, I think Stuart is probably the better one to answer that to some extent, but I think as I've gone through, particularly those instances of loss, actually, I meant to say that those individual instances that we went through, some of them were actually on the claim area and some of them were close by but connected through dreaming, or it would have been a related, a local descent group or an estate group that was next to the claim area. So there was a lot of interconnection. So it doesn't even necessarily have to be directly on the claim area. Obviously, if it has significant connection through a dreaming or something else, or a burial site, for example, that has been destroyed, that has impact on the claimants.
Stuart, did you have anything on that you'd like to bring to the table?
I could only possibly add this. There has to be I'll go back to the expression incremental and accumulative cultural loss. One thing that we resisted was an argument by the government that I described as creeping normalcy, and that is, you take one parcel here, you take another parcel there, none of those parcels really matter, but all of a sudden one day you wake up and you've got nothing left. And it was almost an argument that, well, it's not until we take the last parcel that you've got anything to really complain about. So I remember terming it either as creeping normalcy or death of 1,000 cuts. But so the judge, though, did recognise that there was an incremental loss because there was a bit here, a bit there, and it all added up. And claimants didn't have to point to a particular parcel and its use and say, now it's that one that's wronged me most, or it's wronged me 25%, and the next parcel's wronged me 15%, and the next parcel's wronged me 55%. He accepted that they simply all add up to paint this sort of crushing picture at the end of the day, and particularly where these were ongoing events of some 30 years or so and being recounted by the next generation. Now, the relevant evidentiary standard is a causal connection. Now, the example that Wendy gave is an illustration because the concrete causeway was not on a compensable parcel. It was next to the compensable parcel. The man who had the caravan park didn't have any title over the river. He just did it unlawfully. But when it came to cultural loss, the claim loss wasn't confined to the boundaries of the parcel. And that causeway wouldn't have happened but for there being this grant of the caravan park. There was another example dealing with a ceremony ground where there were, it was no longer used because there was an encroachment of housing nearby. And so they wouldn't go back to that area. Now, the causal connection, it need not be a direct cause, but it just has to be, I shouldn't say just, it has to be a cause. That's a very familiar concept in the law of damages generally, that you don't have to show direct causation, but you must show a causal link to the event.
Thank you, Stuart and Wendy, for setting the scene for how compensation is unfolding today. Now let's turn our attention to how this developing jurisprudence may apply to Southeast Australia. We will now hear from Dr. Mick O'Kane, who is based in Melbourne. Dr. Mick O'Kane is the Research Manager for First Nations Legal and Research Services, the native title service provider in Victoria. He is an experienced native title anthropologist who has worked extensively throughout Victoria and southern New South Wales and Central Australia and Northern Australia and South Australia. He has also worked as a consulting anthropologist in the Pilbara region of Western Australia. Mick, Victoria is in a unique position with the other southeastern states of Australia with regards to compensation, as it was settled much earlier than the more remote and northern regions of the country. Recently, the Teddy Uruk Truth-Telling Royal Commission has begun in Victoria and has sparked much attention. It has been acknowledged that the Commission will inevitably unearth research with traditional owners pertaining to the trauma and feelings of hurt that have arisen due to colonisation. And many are curious to know more about what correlations, if any, this research will have with the types of evidence that will be required for compensation claims. However, as we currently understand, there may only be a small window of time in which an act can be considered compensable. So, Michael, I wanted to ask you, do you think there will be opportunities to link compensation research with existing reconciliation discussions around truth-telling? And if so, what are the opportunities and challenges for this?
Thanks for the question, Courtney, and thanks again to Stuart and Wendy for their contributions. My contribution will be probably more speculative than theirs has been, because we're talking about things that haven't happened yet. I do think that there are opportunities, let's say, for native title research to engage with the kinds of evidence that are, that I would imagine will be given at the Uruk Commission. So there's definitely opportunities, but there's definitely risks. So I suppose the biggest risks is around future arguments for continuity in native title claims, but I'll just circle back to that in a minute. I can see that native title research in Victoria, and if these things happen in other parts of the country, which I suspect they will after this, I think we can provide a really good broad regional overview of the ethno-history of colonisation. And if we look at, we often talk about effective sovereignty in native title. We can provide a view of how that effective sovereignty sort of rolled out as colonials moved into different parts of the state. We can have a look at the impacts that different policies had on the peoples that it colonised. Certainly, it's a good background, or good context to looking at where people ended up and where they were when they suffered particular kinds of trauma over the years, which, of course, you can follow up to the modern day. I think we can also bring, very focused understanding of the ethnography and the ethno-history of specific parts of the country, which I would imagine when talking about things like massacres in Victoria would be very useful. But it would also overlap with the kinds of evidence that I would imagine that the Uruk Commission would hear. I think that's going to play a big part in the truth-telling of Victoria, the greater description and a greater understanding of what actually happened to people and the kinds of sort of tragedies that they were subjected to. And native title understands this, native title anthropology in particular understands these things quite well. We've got quite quite a long history of dealing with them, although we're going to have to change maybe the lens through which we see them, or understand that they will be seen through a different lens than we have been looking through under the Native Title Act. But one thing it will do is provide good continuity and understanding of any compensable act that did occur between 1975 and 1993. I think without a good context, there will be probably very little hope of getting compensation for acts that were committed between 75 and 93, because I think it's probably incumbent upon us to be quite sophisticated about how we use our anthropology, probably go beyond correlations between language groups and social structures, probably also go beyond the loss of certain social structures and have a look at the functions of those social structures and ask ourselves, are those functions still being carried out by Aboriginal communities today in places like Victoria, where, you know, many cultural practices are illegal. People can't bury their people in the sand along the Murray River. People can't do a lot of things that they could have done prior to the advent of British law. But people are still heavily focused on looking after country, and they're focused on navigating country as a place of spiritual power. You know, still doing many of the things that Wendy was talking about, albeit probably with less broader structure around them. But I think there's great risk, and I suppose the risks and the challenges are really about how do we talk about loss due to compensable acts without eroding evidence for continuity. So, I mean, one thing that I worry about is, have we developed a language as anthropologists in which we can talk about, or help Aboriginal people talk about, the effects of trauma and loss on their families, on themselves, on their cultural practice, on their identities, without providing ammunition or without weaponizing, you know, that testimony. I'm not quite sure what the restrictions on the Rook Commission will be as far as evidence. I would imagine a lot of it would be private, but also a lot of it would become public. So we'd have to have I think there's just many conversations to be had between now and then about how does this occur safely. I note that one of the prime directives of the Commission is to do no further harm. That will be a really important thing to adhere to, and it's going to be very tricky as well, because it is traumatizing. You know, as native title anthropology is traumatizing to Aboriginal people, this truth-telling commission will also be. So it's going to have to be handled very carefully, and I think as native title anthropologists have a crucial role to play in how that plays out. I know in Victoria, at least, they've got the Charter for Human Rights is it's a major charter for law at the moment, and it will be into the future. So we as anthropologists would probably have to also think about how we safeguard our ethical commitments to our informants who are claimants on native title claims, and how we, I suppose, a conversation to have with the lawyers is how do we safeguard that information? You know, I'm not quite sure if that information can be requested from native title claims or native title research, or research that went into claims that were withdrawn, but I think it'd be a question to ask. And I understand that, you know, the law will develop in this way, as practice will develop as it always does. And that's something that we won't know until it happens, but we'll have to be looking forward to it, I think, and safeguarding against it.
So Mick, how can anthropology contribute to understandings of the value of land and the value of trade and exchange in relation to issues of possible compensation? How can anthropology offer insight to this valuation process?
I think the second part of the question, you know, how can native title anthropology, or anthropology in Victoria at least, provide an insight into the way land is valued economically and for cultural loss? That's even trickier. So this is really speculating, but I was thinking about this question and thinking that the loss of the ability to associate with country is something that we would profitably look into. So association with country adds a cultural value to the land and the things that come from the land. And the examples I was thinking about was, say, something like a silkcrete mine or an ochre site, or greenstone mining as it occurred in Mount William. And this is a very simple example, and I'm sure there are much better examples when we really start drilling down into this, but just on the surface, I would imagine that those things would be of far more economic value to Aboriginal people as cultural artefacts, or as something with cultural value that they could use as a resource, whether that is a resource for creating artefacts, culturally valuable artefacts, or creating artefacts that became products for sale. And I think between 1975 and 1993, there would be a few cases in Victoria of that association, or that loss of association, leading to a lessening of the value of those resources, or that kind of resource. I think that's an area that we could look into. But I was also thinking about something that Sturt said at the start of the discussion, when he was talking about the Yuruk being probably more forward-looking type of a forum to achieve some kind of reconciliation, which brought me back to W.E.H. Snanner and his notion of every when, which is a really good concept to think about in these kinds of circumstances, because you know, as Wendy was explaining, you know, that kind of the harm and the trauma and the shame of these, you know, compensable acts between 75 and 93, they will always be happening. You know, and in a sense, it clouds the past with this, with an act will cloud the past in relation to a sacred site or a dreaming. So every time people will think about that dreaming, it will bring grief. And then, of course, there is the grief that happened at the time the event occurred. And then going into the future, that grief will continue. So I don't have an answer to how we value that, or whether we will value that, but I definitely think it's something that we should be thinking about. And as anthropologists, if we're trying to in a sense, interpret these things for a broader audience, it would be one of the more important things to interpret well.
Thanks, Michael, for that. That's really very interesting insight. Evidently, the questions raised in this podcast surrounding the applicability of compensation in Southeast Australia are highly complex, and as a collective of legal and anthropological practitioners in this space, we are still working towards a greater understanding of what the future of compensation will look like in these more settled regions. This podcast has shed light on a number of valuable inquiries, such as the opportunities and limitations of this developing jurisprudence in the southeast of settled Australia, the differences between compensation and redress, how anthropologists can reconcile research for the purposes of demonstrating continuity and connection, while also articulating cultural loss through the ethnography of emotion, feeling, and trauma, how anthropologists can articulate incremental and accumulative cultural loss in ways that will meet the evidentiary standards, and whether there are opportunities to link compensation research with existing reconciliation discussions around truth-telling, and what role anthropologists could play in offering insights into the valuation process for compensation. This panel will be presenting at the 2022 Centre for Native Title Anthropology Conference, where we'll be continuing to dive into these discussions and we'll be offering up further food for thought. I would like to thank the panel for their wonderful insights and to thank you all for listening in.